Welcome to the BagMass webinar series. I'm your host, Patrick Flaherty. And if you're anything like me, I didn't get a whole lot of training while I was learning how the practice of anesthesia, how to negotiate a contract or even what a contract was. And we're very fortunate tonight to have a special guest with us. And before I introduce her, just want to thank everybody for joining us. We had a little bit of a hiccup where we had the wrong link for YouTube working. But I think we're up and running appropriately now. So one of the things you can do for us, we'd really appreciate is if you could hit subscribe or link on the bottom of the YouTube video. It helps us with, getting other presenters to come on and present some webinars. And it just lets us know that we're heading the right direction. And if you have any questions at any point in time about what's being presented, put it up in the live chat. We'll get it to Ericka and we'll answer them at the end of this. So I wish I met Ericka before I signed my first contract naively. I didn't know what I was getting into, and fortunately, the group I was working for wasn't trying to really screw me over. But to give you a little more information about Ericka, she is a shareholder for Retzel. She concentrates her practice in regulatory and transactional health care law. She represents individual providers, physician groups, and other healthcare entities in satisfying their day-to-day legal healthcare needs. Ms. Adler devotes a large part of her practice to advising professionals and practices on their contracts, compensation arrangements, and in assisting her clients in the acquisition and sale of healthcare entities. She works with providers in matters relating to HIPAA, fraud, abuse, billing audits, government investigations, licensure matters, and contract disputes. Most of all, she's an excellent writer, and you can find her works on physicianpractice.com and most importantly on bagmass.com. Ericka, welcome to the BagMass webinar series.
Well, thank you. It's great to be here, and I'm really looking forward to talking to all of you today about your employment contract. Now, I don't know who exactly is out there, so I'm going to assume that we have some physicians who are either in fellowship or coming out of training, just recently out of training, who may never have engaged in a contract negotiation before. There may be some of you who have briefly engaged in it, maybe with some luck and without it, and maybe there's some more experienced physicians out there. I'm also going to assume that most of the people listening are involved in anesthesia, and I understand maybe physicians, maybe other providers, CRNAs, etc. So what I want to talk about generally are contract concepts, and most of these concepts go across exactly what kind of licensure you have. They cross over the specialty of medicine that you're in. This is really just about the things to think about when you're looking at your contract, how to ask the right questions, and how to understand what you're signing. So let's start off here. And I always like to kind of show this first slide when I'm talking with a group. And I think it's important. The first thing people think about when they get a contract is they're going to read it and try and do their best on their own. And if they can't, they're going to ask a family member, a brother who does real estate, maybe somebody else who does litigation, etc. Just like you specialize in anesthesia, there are lawyers who specialize in this area of the law and have the experience that really can make a difference. And the way it makes a difference is not only being able to tell you what's good and bad about a contract, but also letting you in on some tricks of the trade, things you can ask for that you may not realize you could get if you were to ask for them. The other thing that's really important about how you negotiate your contract is that it's really worth it to spend a little money up front, because I can't tell you how many people have come to me once they've signed a bad contract, and it can be really difficult and expensive to get them out of it. So although it may seem expensive to try and afford an attorney up front to help you, look around at your options, look around at the costs. I promise you that lawyers who do this a lot will work with you so that you're protected. Now, the last thing I really want you to understand is what is the perspective of each person when it comes to a contract negotiation? Well, the provider obviously wants the best contract possible. They want the most money, they want the most flexibility, they want to be able to walk away whenever they want. They know exactly what their dream job looks like. The employer, on the other hand, kind of knows what they want. They want to maybe make sure they're not paying more than they have to, make sure they're still exercising control over schedule, location, make sure that they can get rid of someone quickly if they want to. As you might imagine, these are somewhat opposing ideas. So the idea is to bring the parties together. Now, when you're very early on in your career, you don't have quite as much bargaining power. So you may not be able to make the demands that you would like to make. At that point, our goal really is to understand what is it that you're agreeing to. are there some slight modifications we might make that would improve the situation for you? And of course, sometimes you are able to talk to the employer and reasonably make changes. But the idea is that you have two parties that are in conflict in terms of their goals. So we need to help the sides reach a amicable resolution. And that's kind of where the lawyer comes in. And the lawyer plays an important role because they can sometimes make or break the success of the negotiation. I like to be the kind of lawyer where it's a win-win. I'm going to tell you upfront, you're not going to get everything you want, and I'm going to explain why. But I like to think that you understand what you're signing and we get you some changes. But there are lawyers who can be super aggressive, who can be super demanding. And when they are the ones representing you, they can sometimes make the employer turn off from you. You might get a no where otherwise you might get a yes because they don't like your lawyer. So it's really important to understand that if you hire a lawyer, that lawyer speaks for you. And I've had contracts withdrawn when the lawyer does not speak for you the way you would want the lawyer to speak for you. So it's really important to understand the roles that everyone plays. I'll tell you the truth, when I deal with my young physicians and even not so young physicians and other providers, I like to help them negotiate for themselves. What I like to do is to give them the tools to ask the right questions and to be able to get the answers that they're looking for. I'm always in the background, I'm always helping, but I think interacting with your future employer tells each of you a lot about each other. It creates the opportunity to figure out what you like and don't like about each other, how flexible you are, the tone of voice that's used, etc. So I think this whole negotiation process is extremely important. And that's why I always like to talk about it at first. Whoever speaks for you, if you're not speaking for yourself, is very important. And how you handle yourself is very important. So I'm going to come back to this at the end. But all the things we talk about are things that you're one day going to want to go to that employer about. And it's really important to think, how do you raise the questions that we're about to talk about? And we're going to talk about that at the end and kind of come full circle. So whenever I first start talking about a contract, the thing I always focus on is, what is it going to be like to work there? All right. Location, call, and schedule are the three biggies for me. Anybody who's reviewed a contract with me knows that I go to those three things immediately. Where will you be working? You'd be very surprised. About 90% of the time, the doctor or the provider tells me exactly where they're working, but the contract is silent. Right? Why is that? Usually the employer wants the flexibility. They either have a form of contract and they tell you where you're going, but they don't want to put it in there. That's one possibility. Or they want the opportunity to move you wherever they want. And that can be somewhat scary for a physician or a provider. So one of the things I like to do is try and seek either specifically the name or place where you're going, or go multiple locations. Often in anesthesia, you might go to multiple facilities. You might be doing all kinds of mobile anesthesia. There's so many different possibilities, but where are you going? So we often want to get that in there. To the extent that we can't, there's a couple of different things we could do. One is we could say that it's locations mutually agreed upon. Sometimes that flies, sometimes it doesn't. A lot of times I like to name the particular locations that have been spoken about and maybe say, and other locations only within X miles. Because one of the things I'm really concerned about is how much time are my providers going to be spending traveling? Nobody signs up for a job thinking they're going to be commuting, right? Or maybe they are, but usually not. And if you're getting paid in some kind of productivity way, then spending time commuting can affect that. So I like to control that location. It's really a lifestyle happiness factor, as I call it. What about your schedule? Well, in every specialty, there's different kinds of schedules. In anesthesia, I very often see shift type schedules, but depending if you're working at a surgery center or maybe a different type of location, you may actually be working more daytime hours. So every contract is different. It doesn't really matter what it says, other than it matches what you were told. And that's one of the things I want to see in there. What I try and stay away from are, you'll work as scheduled. Okay. Can it be mutually agreed upon? Often in many specialties, particularly hospital-based specialties, no. You a month ahead of time, you might tell them when you're available or not available, and otherwise you have no say. So schedule might be something that you don't really have a lot of control over. In that case, it's important to understand what kind of hours. Are we talking regular business hours? Will you be scheduled to work evenings? Will you be scheduled to work weekends? So understanding what it is really important. And of course, to the extent that we can get any control over that, that's excellent. And finally, call. Obviously, unlike many other specialties, anesthesia has first call, second call. I've seen a third call. So anesthesia is very different than other specialties, but most specialties do have some kind of call. And understanding what that schedule is, understanding what say you have in it, how far ahead of time you'll know, what the maximum amount of call is that you'll be required to take is really important. A lot of physicians have an idea in their mind of what the maximum amount is, and they will turn down a job if it doesn't reflect that in the contract. So these are some important things to think about. These are the lifestyle choices. Money matters, of course, but when doctors come to me because they're unhappy with their contract, it's usually location, call, and schedule. So these are three really important things. All right, so I want to just touch on this next topic. You'll see this in every contract, your ability to work somewhere else. And we don't need to spend a lot of time on this, but it does come up in almost every contract and every conversation I have. What else are you allowed to do? Typically, wherever you're working, that's it. You're working there. They usually, if you're full-time, you're exclusive. They don't want you working somewhere else. We want you to, if they do give you permission to work somewhere else, they want you to turn over the money. They want you to ensure that they're not going to be liable for any of those outside services, that you're not going to be competing with them for those outside services. So those are three things doctors always seem to think is unfair when I look at the contract with them. But in fact, it's pretty standard. I use that in my contracts. There's reasons for this. They want to control it. They don't want you competing. They don't want liability. Sometimes we can maneuver this. I always say, do you have something in mind, something you want to do? Let's get it carved out now. And every institution and every group usually has some policy about outside work. So very often you can ask for permission and they'll say yes, but they don't want you just doing it on your own. Okay. And depending on the compensation policy, even if they do give you permission, they may want the money to actually go into your productivity pool. And that's something we can talk about more when we get to compensation. Finally, you'll see at the bottom, I've mentioned IP, intellectual property. This is really important. Many providers have excellent ideas, and very often they relate to medicine, even if it doesn't relate to what you're actually doing in your job. You need to ask for copies of any intellectual property policies and look at that language in the contract. Very often, your employer will own anything you create while you are employed. And although I try and limit that to things you do on the job, using their resources, using their confidential information, or something like that, often these are written so broad as to be able to take control and possession of anything you create. And that's something that I really try and protect my clients from. So that's something to think about. All right, so let's get to the biggie here. Everybody always wants to talk about compensation. It's a big topic. That's probably the number one thing I get asked about. There's no right or wrong formula. Every single group, every single employer that I work with has a different approach to how they handle compensation. The question is, do you understand what your contract says? Very often, particularly for a young provider, you'll see a salary. All right, just a base salary. And a lot of people will want to compare that to data. So you'll look at the MGMA, which is one of the standardized places that you can find out data about providers in your specialty and how much they're making. And they'll come to me and say, hey, you know what? I see that people in Chicago in my specialty are making this, and I'm not making that, and they're not offering me that. You know, what's wrong here? And they'll go in and demand more money. But it's really important to understand exactly what data is being used and what may be different about you compared to that data. So when we look at MGMA data is submitted by people like me. I do a lot of physician contracts, and I and my colleagues submit information to kind of collect that data about what physicians in different specialties in different parts of the country are making. And it may or may not be reflective of young physicians. It may or may not be necessarily a good sampling size. So it is what it is, and we take it as it is. And there's different surveys that are out there, but it's not the entire picture, right? If you're going to downtown Chicago, where everybody wants to be, it doesn't matter what the Midwest region for anesthesia is paying. Downtown Chicago, where everyone wants to be, you're going to get less, and you're going to have to take less, right? And that should be something that you understand. Additionally, a lot of people don't realize that the MGMA data is total compensation. So, excuse me, that number is compensation plus bonuses plus benefits, excuse me, all together. So you've got to take that with a little bit of a grain of salt. Now, the next piece of this is production. Production is that extra. What do you get for picking up extra shifts? What do you get for producing a certain number of RVUs? What do you get for working extra? And that piece varies. Some contracts have it, some don't. Some you only get it after a certain amount of time. If there is a formula there, I always urge my clients to get more information. How are they projecting you're going to do? What does the formula actually look like when we run the numbers? Often they use a lot of legalese and words that don't really make sense. And I'm trying to figure out mathematically what would this look like. So I think that's a really good thing to understand. Don't just assume that it sounds good, so it must be correct, because we're lawyers and we don't always write things correctly. So it's important to understand the actual math behind it. The second piece of this is just bonuses. So the first part was earning money based on your actual work. The second part is a bonus. Sometimes you just get a discretionary bonus. A lot of anesthesia practices, especially older groups that I work with, they sometimes share all their income evenly, which I kind of find shocking in this day and age, but it is actually fairly common. And then they award discretionary bonuses. That means you may or may not get one, and I have no idea what the amount is going to be. I always tell my clients, when you see the word discretionary bonus, assume you're not going to get one. And if you do, you'll be happy about it, because it's entirely unreliable. A second kind of bonus might be productivity based. You hit a certain target and you might get a certain percentage of what's generated either by the practice as a whole, or maybe by you individually. So this is something that we see. It doesn't always kick in immediately in the first year. We don't see it in every type of contract and every type of institution, but these are the kind of things that you could look for. And we all, of course, want to make sure that everything is well written. Again, one of the things we always want to make sure is that we understand how that formula actually works and plays out. I might also mention that one of the first questions I ask a client is, why do they need you? Why is this employer hiring you? And I always want to see that there's actual volume and work to be done. Either somebody has left, or they're picking up a new facility, they're expanding. Your chances of doing well under anything that's production based or productivity based is going to be dependent on there being volume. So I think it's really important that you always go in and understand that if there's no need for you, not only are you not going to earn this, but you may not even have a long-term position. So you always want to be sure that the volume matches what they're putting forth as a formula. Finally, the last piece is benefits. And a lot of times I feel like we don't pay enough attention to it. I mean, you may be getting a little bit less salary somewhere, but what if you're getting the most tremendous benefits, life insurance, health insurance, dental insurance, and it's covering your family and they're paying all the premium? I mean, that definitely has value. And I think sometimes we don't look at that as closely as we should. I always want my providers to make sure they know exactly what portion of a premium they're paying, and also what the waiting periods may be. I've had some, surprised clients who find out that there's 2 or 3 months waiting period and they need Cobra and they didn't realize it at all. So that's something to take into consideration. All right. So what are some of the perks? What are some of the things that you might get in addition to compensation? Well, a signing bonus, a moving allowance, maybe even a fellowship stipend. These are all things that people look for. And my doctors are always afraid to ask for these. Like, if they're not included in the contract, do you think I should ask for it? One of the key things I'm going to tell you about negotiating your contract is, don't be afraid to ask anything, because if you don't ask, you're never going to know. What is really key, though, is how you ask. We do not make demands when we ask for things in a contract. We turn everything into a question. I noticed that there's no signing bonus. Is that a possibility? Or a colleague of mine had their moving expenses reimbursed. Is this something that you might be able to offer since I'm relocating to wherever it is? So we always want to phrase things as a question. It's not as offensive, it's not as assertive, but it still gets the point across, and it softens it a little bit. It shows that you're thoughtful, that you're asking a good question, and usually you can kind of paint a scenario around it as to why you're asking. And typically this works really well. This is the general advice that I give my clients in terms of all their contract comments. Turn everything into a question. We do not make demands. Okay. Now you'll see at the bottom of the screen, it says the word forgiveness. And this is really important. All these extras that you take, they come with strings attached typically. And that is that you're usually locked in for some period of time to that contract in order for those amounts to be forgiven. And if you leave before that period of time is over, you may owe it back. Now, there are some techniques that we like to use to kind of ease that a little bit. For example, I don't want you to pay it back if you die or become totally disabled. Maybe they let you go for no reason. I don't want you to pay it back. But you can be sure that if you choose to walk away or you're fired for cause, that you're going to owe that money back. And it's important to know when you're talking about potentially leaving a job down the road. So that forgiveness element is important to understand. We're going to talk about that a little bit further as we go on. Now, for those of you who might be considering working with a group, future equity might be important to you. It's not quite as important to physicians these days as it used to be when I first started practicing, but I wanted to mention it in case anybody is joining or thinking of joining a small group. I'll be honest with you that most groups do not like to go into detail, but I always suggest that at a minimum, we look for certain features if it has been mentioned to you as a possibility. First of all, I want to know the time frame. They'll let you know by when. I've had doctors stay for years and years and years. They keep waiting and hoping that somebody's going to tell them if they're going to become a partner, but that's really ridiculous. Tell me by a certain date, and I understand that if you don't tell me by that date, it's not going to happen. I'll make my plans accordingly, right? If you do, will it be an equal ownership? So the worst thing would be you wait 3 years, you're offered partnership. Oh yeah, but we're only giving you 5%, and you thought you were going to become an equal partner. So when they'll tell you that it will be equal and that they will treat you in the same manner that they treated everybody else. Excuse me. At the time that you become a partner, they will give you actual documents related to that. So I always find it quite forward if I'm representing the employer and somebody coming out of training and their lawyers demanding to see the shareholder documents. I will not turn that over, and I would not expect another lawyer to. Well, we don't know you yet. We don't know if we like you, and we don't know if you're going to be here, and that's confidential information. So I don't think anybody should be offended if it's not shared. I think that there's a time and a place, and this is a little early in the game. So finally, if you'll notice on the side there, it says rejected. And the reason for that is, say, how do you feel if you're not offered an opportunity to become a partner or a shareholder? I always talk about this with my clients because I think that it can be linked to a reason that you might be able to walk away from your contract more easily. And it does impact your exit strategy, perhaps as it relates to malpractice or the non-compete. And we're going to talk about those. But let's remember, if you're rejected, meaning they're not making you a partner, and you want to leave that group, what are the terms going to be when you go to leave? And now we're going to kind of start talking about that exit strategy. So we talked about the call location and schedule, and that's all about working there. And if we can't get changes to the contract, great. We're going to perhaps enter into it in good faith and hope that everybody keeps their word. But if things don't work out, we need to really think about our exit strategy. And I know it seems somewhat negative to think about your exit strategy when you're just signing a contract for the first time, but that's the time to think about it. All right. So this is just a very simple slide just to show that there's really two major kinds of contracts. One of them, it just automatically renews and it goes and goes and goes. And somebody has to do something to terminate it. That's what we call an evergreen contract. On the other hand, there's something called a contract with an expiration date. And those can be kind of scary. A lot of times people overlook this. But if you get a 3-year contract and it just says you have a 3-year contract, it ends on X date, and that's it. It doesn't renew. It doesn't anything. That makes me a little nervous. What I like to do in those situations is to make sure that we try and get something in there that says, 6 months before, they will let you know if they're going to be giving you a new contract. And if they are, let's get started negotiating. If not, you've got to find another job. So this is really about not waiting for a contract to expire because you thought you were going to keep working there when in fact you were not given a new contract and you haven't interviewed anywhere else. So expiration can be kind of dangerous as well. Keep that in mind. All right, so we're talking about the exit strategy here. A standard contract will have some grounds for how a contract can be terminated, and this is pretty much the major one. So first we have the no cause. This would be either party can tell the other party that they're leaving. Usually it's on 90 to 120 days notice would be about the standard. I get upset if I see something that's 30 or 60 days because healthcare providers need to get on staff at hospitals. They need to get credentialed, and that really is at least a 120-day process usually, as well as interviewing and finding another job. So if you're given a 30 or 60-day notice, you're going to be out of work for quite a while. So I like those no cause provisions to be a certain amount of time. Then we have for cause. For cause might be things like you are convicted of a crime, you're kicked out of Medicare, you steal something. Sometimes they're a little bit more sensitive topics. Um, you do something that affects the employer's reputation or something like that. So there can be a wide variety of cause provisions, and I think they're important to review carefully. What we usually see, though, is at least one general provision that says that if you do something bad or the employer does something bad, that either party can fix it in 30 days and it's cured. So we always kind of look for that provision. Now, the automatic termination provisions are things like death, disability, you lose your license. We're going to see that in every contract. All right. Legal closing, legal/closing in the yellow there. What that is really about is that sometimes there's a provision in the contract that says, due to a legal change in the law, we might need to terminate this contract. I don't want people to get scared. That's in every contract I've ever seen. I've never actually seen it used, but that's a pretty standard provision. I also sometimes see provisions that if we need to close down, we have a right to terminate you. That one a little bit more sensitive about, because I've actually had positions where the department was closed or the institution was closed and they were out without a job. I like to link a certain amount of notice to something like closing or going out of business. And finally, non-renewal. So where I talked about a contract that goes for X amount of time and then automatically renews, sometimes they stick something in there called non-renewal, which is it'll auto-renew unless one party gives the other party 90 days notice. And so then that's another way of terminating the contract, but often that can only come up once a year, right? It's non-renewal of the contract year, which means that if you miss that date, you're going to be stuck there for another year. I dislike those provisions. I prefer termination without cause at any time. So you've got to watch out for those provisions. In fact, just today I was talking to somebody who missed it by 2 or 3 days and now they're stuck for another year. So really have to be careful of those provisions. Now, how do these figure with our exit strategy, right? Think about it. You aren't offered partnership is one example, but what if you're just let go without cause? What if the employer is the one who breached the contract? How do things end? Is that different? Does that affect how you feel about what your rights should be when a contract ends? Those are important things to think about, how the contract ends. So next we're going to talk about the non-compete, and I'm sure you all are familiar with it. I can clear up one thing right away, which is most people say, I heard non-competes are not enforceable anyways. That seems to be like the going line in fellowship training programs and medical schools and everywhere. In fact, non-competes are very enforceable. Most states will strongly enforce them. There's a couple of states where they're not. California, for example, they do not enforce non-competes for employees, but they do for owners of a business. So, it's important to generally assume that your non-compete is going to be enforceable. And what it has to be is reasonable in terms of the geography, reasonable in terms of the length of time, which I indicated is about 1 to 2 years is about normal, limited hopefully to your specialty, not to the practice of medicine in general, although some employers like to do that. And then also we typically see as part of that a non-solicitation, which is you can't solicit patients, employees, referral sources, etc. So that's all pretty standard. So these are enforceable. It's important to understand in your contract whether it's been properly written, but usually these are probably the least negotiable part of your contract. But what I like to do is to see what I can achieve. Can I reduce the service area? Can I tie it to the locations where you spent the most time? And that's where the location issue becomes very important. Can I make it go away if you're not offered partnership, if you're let go without cause, if you terminate for cause, right? If they just non-renew your agreement for no reason. So you can see how those termination reasons might give you an out when it comes to the non-compete. And this is something that I always try and go for. Now, another important piece of your exit strategy is the malpractice coverage. And I always explain this as being, there's two main types of coverage: claims made and occurrence. And just so you generally understand, claims made insurance is the type of insurance that has to be in place at the time a claim is made against you. That means that if you leave your employer and you're sued 2 years later and a claim is made against you, if you don't have insurance in place, you don't have coverage. So when you leave an employer that has claims made insurance, you usually buy something called a tail, and it pulls out your insurance into the future to cover you at that time that a claim is made. The other type of insurance is occurrence coverage. And what that insurance says is that as long as you have it when the event occurred, you're going to be covered. So typically with that type of coverage, there's no tail that's required. You're just covered. That's the best kind, but it's also more expensive. Most hospitals do offer that type of insurance. Also, self-insurance is another way of saying occurrence coverage. So generally, these are the two types of insurance. And when we're looking at the contract, we're looking to see, is it claims made and is a tail going to be required and who is paying for that tail? That's a really important part of your exit strategy. Again, I like to argue the reasons that the tail should not be paid by you. You weren't offered partnership, you were let go without cause, the employer breach, the employer non-renewed. These are all reasons that we might argue that the tail should be paid by them. There are a couple of other options. You can also have a new employer buy you something called a nose policy, which will reach back in time and kind of take over your old malpractice risk from the old employer. So that's something to consider as well. So these are things that you talk about with your lawyer when you're looking at your contract and you consider. But again, the non-compete and the tail are big pieces of that exit strategy. All right, so we're going to wrap up. I just have a couple of final thoughts here. There's always a last section of your agreement that is called I call it the boilerplate section. And this is in any contract, not just physician employment agreements or CRNA employment agreements. And what it essentially makes clear is that your agreement that you've entered into is everything. Those side letters, those emails that you sent back and forth with the employer, those are not binding. Whatever the recruiter told you, it's not binding. If it's not in the contract, it is not going to be enforceable. So as lovely as those promises are, we try and get them in writing. Now, at the end of the day, I really want you to focus on what is important. Coming up with a list of 100 things you want is really not the way to go about it. What is important to you? Is it important to you to have control over your schedule? Is it important to you that you don't want to have to pay for a tail, that you're from the area and the non-compete is the most important thing for you? You have to figure out what's important to you. There can be multiple things, but you have to be reasonable in coming up with that list. You also are not going to get everything that you want ever, no matter who you are. So what is more important is that you understand your contract, good and bad, and that you can live with it. Because once you sign that contract, it's enforceable against you, and you need to be able to live with it. So those are some of the things that you really need to think about when you're looking at the contract and thinking it through. Can you sign with this employer? Can you be bound by these promises that you're making to them? All right, so that's it. I think I've covered everything that we wanted to cover today, and I'm happy to take any questions that you might have.
Ericka, I really appreciate that. It's always nice to hear this information coming from a professional because, like you said, you talk about the fellowship. A non-compete is not enforceable. Those are definitely rumors that go through to the ORs, just conversations like this. But we do have a question from James Zetz. He asks, with many groups being bought out by anesthesia management companies, is there a way to protect yourself if you are on a partnership track and there is a buyout? He says, is it possible to have in my contract this scenario to ensure I get some portion of the buyout?
I think that's a really great question. I actually talked with a radiology practice about this today. So one of the things you'll understand is that in every contract, in that boilerplate provision section that I just talked about, is something called the assignment provision. And what that provision says is, hey, you doctor, you CRNA, you can't give your contract away. It's personal to you. But we, the employer, can give your contract to anybody we want. So what happens is if somebody sells out to a national company or another group or a hospital, whatever it is, they usually simply assign your contract. They don't need your okay to do that. All right. So you're not going to be able to stop that from happening. You're usually not in a position to negotiate a better deal or anything. Sometimes I actually, depending on the situation, it rarely works with hospitals or institutions, but does work well with smaller groups, is to say that if you try and assign my contract, you have to get my permission. And if you sell the company and sign my contract, I have a right to walk away without a non-compete, etc. Now, what you're asking is slightly different. Can you get something? Today, I had a conversation with one of my clients who is bringing in a new radiologist. And what he said to me was that he wanted to put something in this contract that said that in the event that they sold in the first 3 years before this doctor became a partner, that they would give that partner a percentage of a shareholder share of the purchase price, depending on when it happened. So, for example, 25% of a shareholder piece of the pie if they were to sell. And so, yes, I have seen those provisions. I've done those before. It hasn't actually come up in quite a while. And today it just happened to be talking about it with someone. It is doable, but it's not something that most employers are open to. It depends on your specialty, how hard you would be to replace with another candidate who wouldn't ask for such a thing, right? Um, and but I think it's a great thing to ask for. Like I said before, I don't think that there's any question you should be afraid to ask. It's always about how you ask. So you wouldn't say something like, "I'm not really interested in coming unless you give me something that if you sell, I get a piece of it, the sale." I mean, obviously that's not going to fly. But you could say something like, "Hey, with all the transactions going on, I'm really concerned about joining a group that's only going to turn around and sell. I've heard this from a lot of my colleagues. You know, what can you do to give me some reassurance that I would be part of that um, the future group, part of that transaction, that there's an incentive for me to take the risk, right? So it's really all about how you ask the question. And I would be honest with you that that's a pretty sophisticated concept that a lot of lawyers don't do that. They've not ever suggested it to their client, and they wouldn't know how to answer that question. But I think it's a great idea. Certainly, I've seen it from time to time, but it is not that common, particularly, not in outside the private group setting.
Yeah, I talked to a lot of the residents, and I've seen it occur at a couple different places where people did sign on to a practice group, and within a year or two, they next thing they knew, they were getting bought out by a larger company, and they were
Right.
quite upset, and it's understandable, and they didn't foresee that coming.
Right. I've had it happen, a couple times this past year where we were mid negotiations for a buy-in, and a private equity group has come in and interrupted the transaction, and but the owner of course preferred that deal, more money immediately, etc. And in both those cases I had actually negotiated for my client that they would be released from the non-compete, um, as if that was to happen. So it worked out well. One of them chose to leave, and the other one actually negotiated a much better contract for themselves with the buyer. And one thing that's important is that everybody who plays a role in an organization is important to a buyer. The last thing a buyer really wants is for everybody to start walking away when they're trying to buy a practice, because the valuation is done based on the contribution everyone makes. So I don't think anybody should think that they're not an important piece of that pie, because typically you can negotiate something for yourself that makes the deal, palatable. Not always, but very often. So you shouldn't necessarily always want to run away, but you should look at your options.
Mhm. A lot of great information came out of this, and the one piece I want everybody to take away from, I think, is very important. I never really considered before was, a lot of the stuff I've seen on negotiations is on TV or listening to other podcasts and stuff like that. I really like the idea of asking it as a question, as opposed to making a demand. I think that just can go a long way with getting what you ultimately want from the job. I'm just curious, from your perspective, how do you know when to keep pushing the subject matter versus just backing off and saying, let's just move on to a different battle?
Well, I think that's a good question. Typically, the way the process usually works with a physician is that I will talk through the contract with them, and we'll kind of go page by page. And when we're done, I very often will send them a summary of, let's say, the 15 things that we thought were most important about the contract. Sometimes it's just like ask for a copy of the policies and procedures, or this or that. It's not all like necessarily significant items. But then I say to the doctor, go through this list and come up with what's more important. And then often the next step will be that they will go and reach out to the employer and say, hey, you know what? I have some questions, some comments. What's the best way to share them with you? And I always say, wait for the employer to kind of tell you what they want. So very often they'll say, oh, send me an email and then we'll have a call and we'll talk through it. Like that would be very typical. Usually that email will lead to a response from the employer. No, I'm sorry, we can't do this. This is our standard. Or, yes, I think we can. Do you want to propose some language for that? So we start off with that first level of yes and no. And then we go back and we say, oh, thank you so much for this. I noticed that you said no, to this and this. Can we talk about that? So there might be, at some point after, I would say, maybe the third round, we're sorry, this is the best we can do. kind of comment that you get, right? And I think you kind of have to be able to read a little bit of the tone. One of the things I try and really get a sense when I talk to my clients is what kind of person are they? Sometimes I'm talking, especially, I hate to, I don't want to badmouth any surgeons, but surgeons are super aggressive sometimes. And often I will say, you know what, let me write the questions for you, because I can tell by talking with them that they're super assertive and that they're not going to really have the conversation in the way that's the most efficient way. And often those conversations are much shorter. The back and forth is a little bit shorter. I said no, as opposed to, um, well, we gave it some thought and we don't think we can do this, maybe next year, or something like that. So I would say generally, if you're easygoing and you try and be flexible and ask things as questions in cooperative, collaborative way, I would say, you're going 2 or 3 rounds, and then you should be able to read the signal that you've gone as far as you can go. At that point, though, sometimes people still say, oh, can you just call and talk to their lawyer? And just, this is what is so important to me. And I might do that. But sometimes you get cut off much earlier. I will tell you, if you're working with a recruiter or a larger institution, they do have a lot less flexibility, and sometimes the answer is the answer. So a lot of it comes into just kind of being able to read some of the signals that are being given to you. One other piece of advice I'll give is that a lot of lawyers will just kind of create a red line immediately and prepare it and send it to the other side. My clients, when they're the employer, are somewhat taken aback by that approach, unless they were asked if red line would be acceptable, because what you're doing is taking somebody else's document and modifying it. You're not having conversation, you're telling them how it should be written. And it comes across as very assertive and aggressive. And I always say to my clients, ask them what they prefer. Would they like a red line? Would they like this? Would they like that? And we follow their lead. And part of my approach really is, I want to create a goodwill and good feeling. I want you to have a nice relationship. When I'm done at the end of the day, you still have to work there and they have to like you, right? So I don't want to do anything that makes them not like you because they didn't like me or what I told you to do. So I think a lot of it, sorry, kind of a long answer to a question, is read the signals. I would say 2 to 3 back and forth, and then hear what they're saying if they're saying no.
Excellent. I think that's a great answer. I think that's going to for tonight. Ericka, we really appreciate having you on. For everybody out there watching right now, make sure you hit the like button. What we'll do is in the show notes, we'll put Ericka's contact information in there so you can contact her if you have any questions, or better yet, use her in your next contract negotiations. So good luck, everybody. Have a great night, and remember to bag mask.